other four a crowd at the back #1 channel and news a coso and the epa ever mine when you're calling your question of panel. Yes, only so not a dear brum no matter the coso the epa ever mine on a have a Ghanatube so now mamma said training news I coso or Ghana has a other four eternity the cofa Eddie brum not almost or Martin in the young quem. Then go to young and some I coso and the epa ever mine.
Getting into one of the major cases we've been following quite closely as well regarding the number of cases the Attorney General Dr. Dominic Ayine has been updating the nation on regarding investigations into Boahen and matters arising. When exactly is the trial to begin? That's one of the major issues that happen in court today, is it not?
Yes, Alfred, it's one other case like you did indicate that people are looking out for. The last time we did indicate that you recall an application had been made by the lawyers for the former National Signals Bureau boss. The application had been made that they wanted details of the operational accounts of the National Signals Bureau, National Security Operational Account for that matter, since 1992. Now we know that there were some disclosures that were done which covered the 2017 period. So now, they had insisted that they wanted from 1992. The court dismissed that application today. And now the court proceeded to indicate that the trial will commence on July 18. And so the case that many of you are asking that they are going to court and coming back, when will the trial commence? The date we have now is on July 18. What we do not know is whether the lawyers will be taking any other step with regards to this particular process by way of maybe going to a higher court to ask the court to take a look at the decision that has been taken by the High Court in this particular instance. But for now, they do not have access to the operational accounts from 1992 as they had wanted. They are going to come back on July 18 for the trial to commence. Another case that
I want to hold on to that point. Let's
right.
go back a bit. Let's go to the court. Earlier today, Samuel Atachian, who's lawyer for Boahen, spoke to journalists after this decision by the courts to now put the date for the trial to begin for July 18. He was not too happy about it, as expected. But take a look at this.
How was it that they were able to bring President Akufo-Addo's National Security Coordinator's operation account? Where did they get it from? Why is that the rest of the operational account, they don't want to bring it? What document is it in this realm that the Attorney General should not go and fetch? But it's convenient to hide some documents and bring some. And even those things that they brought, they've removed some of the documents. What kind of trial is this? That Attorney General believes that there are certain documents they don't want to divulge. You know, a court of law should not aid evidence gagging and will challenge.
Well, so that's those concluding words there by Samuel Atachian that, in his view, the court of law should not gag the provision of evidence in full as expected. They said they're going to challenge this.
it. Yes, at least that answers the other parts of the question
Absolutely.
that we were asking about the next steps they intend to take.
Perfect. Now, in challenging it, then what that means is that going to affect the trial beginning in itself, as has been communicated today, July 18, if they decide to go ahead with that position he just put out that they're going to challenge this?
It depends on the step they intend to take. I mean, they could, in simple terms, proceed to file an appeal at the Court for Appeal against this decision. They could also, in asking for the appeal, also make a request for the trial at that level to be put on hold. Because the points they intend to make, and from what the argument is advancing, suggests to them that, to an extent, the defense they intend to put across could be found in the pieces of this account records that they need. And so it depends on what they intend to put across by way of their approach, and that will determine what they need. But if the trial can proceed without they having access to this, because mind you, at the beginning of the trial, obviously, the prosecution will be calling its witnesses first. And so that is
Absolutely.
how things are going to proceed by way of that. You recall this other matter we brought our viewers updates on, the Republic versus Professor Christopher Miawe-Kumfi and another, the SkyTrain matter. We know that they had made an application also for some parts of the matter to be referred to the Supreme Court for interpretation. They had made reference to the protection of public property law, the SMCD decree, and how it contravenes Article 19 of the Constitution that deals with fair trial and all those matters over there. We know that the AG had asked for an expedited hearing because the court had originally fixed July 9 for the hearing. The AG says they should do it today on July 3. The Attorney General was in court. Deputy Attorney General Dr. Justice Remsai was present in court, but the case was not called at all. We didn't see the lawyers of the accused persons who had even made the application present in court as well. And so for now, we're just looking out to the next date on July 9 to see what is going to happen, whether they would come back. And now the question will now remain that they will just may have to move the motion for the interpretation reference to the Supreme Court.
For any for some I also any the epa or manama edika editie no na say we ni egusu a wo hwe e me hwe pan say wutie na adwentwe a wo efa sansem no ja fefe edi amame e wo comment section yenkwen ni eguti nsem no ne etoaso
Which they are asking for. One more case we can tell our viewers about is Republic versus Charles BCU and others. It's a matter that has been pending in the courts for a while. Now the update is that the OSP has withdrawn the charge sheet, the old one that has been filed for a long time now. A new charge sheet has been filed with 2 additional suspects named. The court took the plea of the 2 suspects, but one was absent, and so that is what transpired in court by way of this particular case as well. So it's one case that has been up in court for a while now, and we know that Mr. BCU's lawyers had filed multiple applications throughout the court proceedings. And so that is it by way of updates with what transpired in court today, bringing you the latest right from Patricia Esiedua Agradaa all the way to the National Signals Bureau former chief, and now ending with Charles BCU.
And important, and you know, the after Agrada's court sentencing today and the prison sentence of 15 years, the conversation about others who are doing the same thing that she's been in prison for also came up. So at least from the Ghana Independent Broadcasters Association perspective, this development should serve as a basis now to expand the scope of focus for these other TV stations broadcasting this same content of money doubling and so on to be also roped in to suffer the same consequence, as it were. We have it. But earlier we spoke to Christian Mamhesi, his private legal practitioner, on this. He also made the same point about how this should now propel some level of action to be taken beyond just a caution from the National Communications Authority to television stations broadcasting the same content that the founder and leader of a heavyweight church has been now imprisoned for. Take a look.
Yes, I mean, indeed, if the records prove that it was a first-time offender, the mitigation would have sustained for her. But as the accused lawyer sought to, or the defense lawyer sought to put in the mitigation, the opposition by the prosecution indicated that this is not the first time, so she's not a first-time offender like your reporter mentioned, and that she had been acquitted and discharged, and she was fined 10,000 Ghana cedis at the time. And so the court can basically just not take what the lawyer is saying hook and line. And if you look at the charlatanic practices, it deals with the publication of advertisements or notice to the public, which relates to fortune telling, palmistry, astrology, or use of any kind of factual means or device to deceive members of the public, so to make unjust enrichment from them. So it deals with everything of intention to defraud. That's why it is linked up to defrauding by false pretense, which is the definitions are listed in section 131, 132, and 133. And with this, the prosecution had to do was to establish that there was a false pretense or personation, basically communicating a false belief to members of the public, as it were the church members or people who watched her on TV. And also the mens rea, that's the intention to defraud, that they also had to prove that indeed she intentioned herself to deceive and obtain such unjust enrichment to herself, and that there was transfer of ownership. That is, the false pretense must be induced on the members or those who had the opportunity of that notice, and as a result of that, it induced the transfer of ownership of property to her. And that is what was discharged. It serves as a deterrent to some section of the clergy who sometimes use faith to exploit the masses. It is time and rife that the law works. Indeed, we have laws that govern all of these things. You cannot just use faith to procure unjust riches and believe that you surround yourself with macho men and service personnel who will protect you. When the law comes for you, it will pick you out of all of those people, and your freedom to associate, your freedom to worship would all be curtailed.
Well, that's Christian Mam Hesse, is private legal practitioner, sharing his thoughts there as well. Joseph, I know.
And I'm wearing a receive a perfect was in some Michelle, and now a friend, ha, a Ghanatube, so.